Hi all, and thank you for joining me today as we ask some common questions from prospect clients about division of assets. I'm joined today with part of the family team who can help with our inquiries. So Nicola, when can I start proceedings for division of assets?
Well, it's advisable to think about, and if possible, discuss with your partner your finances as early as possible, and certainly to take advice at an early stage as possible. Where there are disagreements and disputes, these can take a while to solve with experience. The court cannot make an order or approve a consent order until you have the decree nisi in the divorce. That doesn't mean that you can't get things in place beforehand. And if you think you need to get your case before the court because it's complex or you're just really struggling to get anywhere with your spouse in any sort of agreement, then you can issue proceedings as soon as a divorce has been issued. So we will advise you to get on with the divorce process where you need to resolve those finances. If you have urgent financial matters to resolve, such as freezing orders because your spouse is possibly dissipating assets, which means just doing something you shouldn't be doing, or maintenance pending suit, which literally means maintenance while proceedings are ongoing, the court can hear these once you've issued proceedings, regardless of what stage the divorce is at. You need to be aware that there is a requirement to attend family mediation before going to court, unless it isn't suitable, such as, if there's been domestic violence. The mediation, whoever does the mediation will advise you as to whether the case is suitable. It can help in a lot of cases. If not, or if your spouse isn't willing to attend, you get that form and then you can get on with issuing proceedings.
Okay, so Steph, what if my partner and I cannot reach an agreement regarding division of assets?
Sure. So ultimately, we always advise our clients to try to reach agreement because it's more cost effective and it means that the division of assets can be dealt with more swiftly, leading to less stress and allowing you to ultimately move on with your life, which is what you are trying to do. But it's not possible for everybody. So there's a couple of things you can do to try to avoid issuing proceedings if necessary. One of the first things that you might consider is instructing a solicitor. And the reason for that is because the solicitor can assist in proposing informal disclosure. And then once both parties are happy with the disclosure, we can, as our role, propose potential settlement offers that we think are suitable, but also that are going to be potentially accepted by the court. And you will know yourself whether you think that a solicitor will be able to assist, whether you are close enough to negotiating, or whether you just think that the proceedings are going to be required straight away. So it's a decision for you to make. The second option, as Nicola has mentioned, is mediation. So the court requires mediation because they see it as a reasonable way of parties trying to negotiate without needing to issue court proceedings. So that's why the court has it as a requirement before issuing proceedings. And the mediator will discuss with you the considerations that you have and will invite the other parties to attend a mediation session. And of course, if that other party does engage in proceedings and you are able to negotiate, then it can be put into a consent order and proceed on that basis. So it's another way of narrowing the issues. Now, if the other party doesn't attend the mediation, or the mediator thinks that the differences are too vast for the mediator to be able to assist, they can provide a mediation exemption certificate, which then can be used to issue court proceedings anyway. And it's worth noting that that exemption certificate lasts for 4 months. If you wait longer than 4 months before you issue proceedings, then you'll have to obtain another mediation exemption certificate. So that's 2 options that you can try just before taking that step of issuing court proceedings.
Okay, brilliant. And Paulina, what does a division of assets look like? So what factors does the court take into consideration?
To be honest, the court takes everything into account. So basically, every kind of circumstance that's surrounding a division of assets and the financial lives together. So, for example, the court is considering the needs, financial needs, the standard of life they had before they decided that they want to they don't want to live together. Also, how it looked like, how they shared their finances. So the problem is that many people think that the court is taking into account conduct of the parties. However, it's not entirely correct. So for example, yes, the court is taking into account conduct of the parties, but when it comes to financial conduct, so for example, when one of the spouses is hiding income, is hiding assets, however, conduct like for example, domestic violence is not really taken into account. So basically, everything that the court can think of can be taken into account. So for example, length of the marriage, so earning capacity of both parties. So the court is even taking into account things like pension schemes. So the court is ensuring that both parties are covered. So that's why the starting point in division of assets is 50-50 split. That's why the court is trying to ensure that the split, that the division of assets is really fair. So basically, that is taken into account by the court. However, when the parties try to resolve division of assets on their own, so for example, they want to reach an agreement and then have a consent order, they take into account what they consider to be right and fair. So for example, when you've got financial proceedings, there's form D81, you need to disclose all your assets when it is like consent order. It is more complicated when we've got proceedings when you cannot agree. It's Form E, that's very long. So that's why the court can ensure that everything is in place, that everything is disclosed, and division of assets is fair. So basically, you can do it yourself. You can write down what you've got, what your spouse has, what you've got together, and then you think, okay, we can split it like that. We can split the house like that. We've got, for example, 2 cars and we can split them like that. So that's how it looks like. Okay,
Brill. And Nicola, obviously with taking into account everything that is given to the court, how do they decide what is correct? So for example, some clients are saying that they are the only one on the house mortgage. So why should their partner be entitled to it as well?
Well, the court's primary consideration, as the law's developed over the years, comes down to fairness. They will take into account many factors that Paulina will have mentioned. These factors are set down in legislation, and the court must consider all the aspects of the case. They will prioritise welfare of any children of the family, and thereafter look at the party's needs. That's the way the case law is developed. So you must bear in mind every case is different and is considered on its own facts. So that's why it's important to take advice and make disclosure of all your finances and your spouse's finances as well at an early stage as possible, so we can look at what the court are going to consider and maybe sort of look at what would be a reasonable settlement there. There is no set formula such as the person paying the mortgage gets to keep the house. Financial contribution in a long marriage, which you say more than 10 years, maybe could be less, will be considered equal to the contribution of, say, bringing up a child or making up a nice home. So that home may be a home for the child who's going to live with the mother, and that mother doesn't have the mortgage capacity. There's not enough equity in the house to buy another house, and thereafter the court are going to have to consider whether that house needs to remain in place for the mother and the child, even despite the fact that the other party's been paying all the mortgage. So people get a little bit upset when they realise that just making the financial contribution doesn't mean that they will get what they've put in, because other factors will be considered by the court. The best awards, in my experience, that the court make are the ones where neither party are actually completely satisfied. That's why they're in court, because they both want different things. They're both, they can't reach agreement. And on reflection, after the stress of all the court proceedings have subsided, they tend to realise it probably was fair. Of course, the court can only occasionally, I would say, make errors in what they award, and on that point you could be advised on the prospects of appealing, but I would say this is rare. This is why it's important to get advice for each stage of the process and understand what it is that the court take into consideration, because there is no formula, there's no right way of doing it, and every case is different and decided on its own facts, with the court following certain rules that have developed over the years.
Okay, yeah, that's understandable. So, Steph, what are the steps in division of assets proceedings?
Okay, so if you've realised that you're not able to get consent in the division of assets, then the next stage will be to issue an application to the court, and there's a court fee that's paid when you make the application. When you make the application, the court will issue that application and serve it on the other party. At the same time, they'll provide an order listing the first of potentially 3 hearings, and the first hearing is called the first appointments hearing. Before we get to the first appointment hearing, the court will list some directions that parties should comply with so that the case is ready for the first appointment hearing. The first main direction is the Form E, which has been mentioned previously, and this allows for formal disclosure of all assets, income, liabilities, and also gives parties their first opportunity to tell the court what it is they want from these proceedings. That will be directed, and then a few weeks later, each party will be able to raise questions of the other party's Form E. So that's on the basis that you've considered the Form E and you think there's either something missing or you'd like to know something more about what has been disclosed, and you can do that in the form of a questionnaire. At the same time as providing the questionnaire, you can provide a chronology of the relationship and a statement of issues, and this is to assist the court in being able to understand what the issues are. And then the first appointment hearing will be a case management hearing. So the court will see what the issues are between the parties and what directions can be listed in order to narrow those particular issues. So for instance, if there's a particular dispute about an asset and the court thinks that witness evidence will assist the court in determining the dispute on that asset, then they can order witness statements are to be filed. Again, there might be a dispute about the valuation of the former matrimonial home or any other asset between the parties, and in order to narrow that issue, they might order that these assets are formally valued. And the point of these directions are then to lead to the second hearing, which is the financial dispute resolution hearing. At this hearing, both parties should be satisfied with the documents that have been provided by the other and should be in a position to consider what form of settlement they are looking for. So prior to the hearing, parties will be encouraged to try to settle, and then at the hearing, again, the purpose is settlement. So how can the court assist in the parties reaching an agreement? So in this hearing, it's without prejudice. So the judge will give the parties an indication of what would happen if it went to a final hearing to try to see if that will help the parties to agree on a settlement. And both parties can be negotiating before and after the hearing with the ultimate goal, again, of trying to settle. That might not be possible. The differences between what each party want might be too wide, in which case the court will list a final hearing. Before the final hearing, the parties might be expected to file a further witness statement, which is to comply with the legislation that Nicola mentioned before in terms of what the court considers when dividing the assets. So the purpose of the statement is to give the court the information that the court needs in order to determine how the settlement should look. At the final hearing, the judge will listen to both parties' evidence and will ultimately make a decision as to how the assets should be divided and whether one party should be providing the other party with part of their income. The reason why the court does try to assist in the financial dispute resolution hearing is again to avoid the costs of a final hearing. Once the final hearing is reached and the court provides an order, unless you've got grounds for appeal, that will be the end of the proceedings.
Okay, and Paulina, obviously these proceedings that Steph's just gone through, how long do these normally take?
Yes, that is a very common question. To be honest, it is not possible to answer because, as Nicola mentioned, every case is different. Steph's mentioned it as well. And when we have a consent order, of course, it is taking less time for the court to consider it. So, for example, when there is a consent order, the court is saying that it's going to take around 3 months for the court to consider if the court's going to accept the consent order or not. And usually they are complying with the timescale they provide us with, so 12 weeks, therefore 3 months. However, when there is no agreement between the parties and when the parties do need to go through all these steps just mentioned, it is taking a lot of time. So, for example, it can take a year or even a year and a half. Of course, it depends if we only have 1 or 2 hearings or if we need to go to final hearing to resolve the matter. So it can go from 3 months to even a year and a half. That's why it is better to try to negotiate with the other side to try to reach an agreement, because it's much cheaper and it's taken 3 months around rather than a year or year and a half.
Of course, okay. And finally, Nicola, what are the services provided by Optimal Solicitors regarding division of assets?
Well, we're here to guide you through the process with every step of the way, really. We can advise you from the outset and help negotiate a settlement with your spouse, guide you through the mediation process, even though this is something you attend alone or with your spouse and the mediator, and we can help you alongside it if necessary to keep giving you that advice. And then if necessary, of course, we can guide you through the court process, including representation, you know, making sure we get the right barrister for you, etc. And assisting on such matters is always on an hourly rate basis. We do all we can to make sure we'll keep your costs reasonable, won't let your cost spiral, and update you at every stage of the way as best we can as to what it is likely to cost. Not everybody needs help to reach an agreement about how they should divide the matrimonial finances. So if you reach that agreement with your spouse, we can draft that consent order for you and file it at court, and we can do that by way of a fixed fee. The amount of the fixed fee will depend on the complexity, and obviously if you contact us, let us know what the agreement is, we can then advise you as to the cost. Even if you don't have any assets, nothing to divide, we would always recommend that you file a consent order with the court, as this is the only way to end your financial ties with each other and prevents any claim in the future, say you win the lottery or something like that. So yeah, we can do that for you for a low fixed fee, but yeah, if you contact us and let us know your circumstances, we can advise you as to how much things are likely to cost for you, and like I say, we can help you at every stage of the process.
Brilliant. Well, thank you all for joining me today, and anyone who needs further help, please get in touch through our Facebook page, or alternatively, our details will be included below. Thank you.
Thank you.